Right. So welcome everyone to the Federal Indian Law MCLE. Thank you all for being here today. We are expecting a great turnout. My name is Rianne, and I'm from the San Diego Law Library. And we have Mark Vezzola, Deputy General Counsel for Pechanga Band of Indians, as our speaker today. And so before we get started, I would like to go over a few bits of housekeeping. Um, First thing, this is a CLE presentation. And for those of you watching it live today, you will get a certificate of attendance from the library by email once we, verify who actually attended today. And if you are attending today's session by phone and you would like CLE credit, please send us an email with your name and phone number as soon as this class ends so that we can document that you actually did participate. And also everyone should have received a handout for this presentation, but if you did not receive it, please email the reference desk at info@sdlawlibrary.org. We did get a few bounce backs when we sent the handout earlier. Also, if you are watching the recording of this video on YouTube, unfortunately, we do not provide a certificate for recordings, but you can access the self-study log on the State Bar's website, and there's also a link in the description box below. All right, so back to those watching live on Zoom today. This is an interactive session, and you can ask questions by using the Q&A function at the bottom of your screen. You'll see two speech bubbles, and you can choose to ask questions with your name or anonymously, whichever you're more comfortable with. And we do hope to get to most of the questions by the end of the presentation. And finally, at the end of the session, you will see a link for a survey. If you can, please just take a moment, fill it out, and we would greatly appreciate your feedback. Well, all right, that's all I have, and I'm going to turn things over to Mark.
Thank you, Rianne. And thank you to the San Diego Law Library for inviting me to speak today on federal Indian law. We are already in the first week of November, and November is Native American Heritage Month. And I am speaking to you today from the land of the Pechanga, who are known as the Luiseño people, or the Western Luiseño people, at my office in Temecula, California. We are on the Pechanga Reservation. I do see a question already. Do you have a list of the attendees? And the individual who asked that question came up as anonymous. So I am not able to see your name. If you want to add that to the chat to make sure Rianne has a record of it, that's probably the best. So let's get into it. Okay, so we're going to be talking today about federal Indian law. And federal Indian law, in a nutshell, is the federal government's policy and laws that regulate its interactions with Indian tribes across the United States. So federal Indian law implicates Congress, the Supreme Court, and the President of the United States. And we're going to talk about its origins, where federal Indian law comes from. We're going to talk a little bit about what tribal communities are like today, especially in Southern California, and some jurisdictional issues that might be interesting for you to be aware of. So federal Indian law has its foundation in the Constitution of the United States. So when the Constitution was drafted in 1787, at least two sections of the Constitution or two articles of the Constitution are relevant to Indian tribes. They were relevant in 1787 and they remain relevant today in 2024. The first is in Article 1, Section 8. And this is the part of the Constitution that enumerates Congress's powers. One of those powers is to regulate commerce with Indian tribes. And over the years, this has become known as the Indian Commerce Clause. The Indian Commerce Clause was later justified as the source of Congress's plenary power over Indian affairs. So Congress has rather uh, wide-reaching authority to make laws that affect Native Americans and tribes. The second part of the Constitution that's relevant to Indian tribes is the treaty power, and this is found in Article 2, Section 2, the part of the Constitution that deals with the commander-in-chief's powers. So Article 2, Section 2 says that the president shall have power by and with the advice and consent of the Senate to make treaties. And we usually think of treaties as agreements between two or more sovereign governments. And this is actually the way the United States government dealt with Indian tribes from actually before the Constitution, going back to the American Revolution, right up until 1871. And that is actually a hard stop to the treaty-making process between the federal government and Indian tribes, which I'll talk about a little bit later. Treaties were actually nothing new, even in the 1770s. Several European colonial powers determined and regulated their relations with Indian tribes through treaties, and the United States, even in its infancy, adopted this practice as well. The very first treaty made with the United States and an Indian tribe was made with the Delaware people in 1778. Now, as I said, federal Indian law is really where Congress, the White House, and the Supreme Court come together to determine policies that affect Indian tribes and individual Native Americans. The Supreme Court, in a span of just really 9 years, came out with 3 significant decisions that helped shape, in a significant way, federal Indian law. And these decisions were made in the 1820s and the very early 1830s. I won't go into all the details and the background of these cases, but they are very interesting. And they are still highly relevant to Native people in the United States today. The first of these cases was called Johnson versus McIntosh, and neither Johnson nor McIntosh were Native. They were both white American citizens who were in dispute over who had title to a particular piece of land. The Supreme Court came down with a decision that cited the original principle that, according to the Supreme Court, said that title to land goes to the nation that discovered it. And I put in brackets Christian, as in Christian nation, because there are a lot of words in this opinion that reference heathenism, Christianity, the will of God. But the bottom line was the Supreme Court held that Indians didn't have the right to sell land. They merely had a right to occupy land. In other words, they were not considered the discoverers of what was then the United States, even though everybody generally accepted the fact that they were there first. The second case is called Cherokee Nation versus Georgia. So this was decided just about 8 years later, but written by the same Supreme Court Justice, Chief Justice Marshall, who authored the Johnson versus McIntosh opinion. This case held that Indian tribes are neither foreign nations or states. They are rather something different. In the Supreme Court, for the first time that I am aware of, used the phrase domestic dependent nations. Domestic because these tribes at the time were within the borders of the United States. Dependent because in the minds of the Supreme Court justices, tribes were dependent on the United States. but nations in the sense that they still had some autonomy, especially over their own people. Finally, we have Worcester versus Georgia, where the Supreme Court, again in an opinion authored by Chief Justice Marshall, held that the Cherokee Nation, even though it wasn't a party to the case, the Cherokee Nation is a distinct community occupying its own territories with boundaries. And within those boundaries, the laws of the state of Georgia have no force. So this is significant because this decision is telling us, really the world, that state law generally does not apply on Indian land. And the little bit of background I will give you is that both Cherokee Nation versus Georgia and Worcester versus Georgia, both of those cases essentially came out of the same set of facts. The Cherokee Nation had a treaty with the United States because under the Constitution, it is Congress that has the authority to manage Indian affairs, and it is the White House that can negotiate treaties with Indian tribes. So the Cherokee Nation entered into a treaty with the United States government in 1819. But because the state of Georgia believed that the Cherokee Reservation contained gold, they wanted to make life so unpleasant for the Cherokee, they began passing a series of laws that would make the Cherokee want to move off the reservation and preferably out of state. And then Georgia and its citizens could reclaim that land and get access to the gold. So here we have the Supreme Court after telling Indian tribes that they're really something else. They're not states, they're not foreign nations, they're domestic dependent nations. And then fast forward 1 year, and the Supreme Court is telling these tribes that state laws have no effect on your reservations because those reservations exist as part of the tribe's relationship with the federal government. So only the tribal law and federal law apply there. State law can have no force. So essentially that third case was a victory for tribes. But then look what happens in rapid succession over the next 4 decades. And most of this, I must say, happened to the tribes, not with the tribes, and certainly not with their consent. During the midst of these Supreme Court cases, which have been referred to as the Marshall Trilogy, we have Congress passing the Indian Relocation Act, which required southeastern tribes to move west across the Mississippi River. And this included the Cherokee Nation, which at this very time was fighting to protect its rights and its land at the Supreme Court. I noted, because I think it's important, that this was a law that happened to the tribes. They had no consent or say in the matter. And then less than 20 years later, the California Gold Rush started, which increased the population of California exponentially and put an increased demand on land and resources and on the native peoples of California. It was a time that was really devastating for California's indigenous population. By some estimates, the gold rush triggered a 27-year period, barely one generation of population decline for California natives. Estimates are as high as 80%. So that's an 80% drop in population for California's native peoples between roughly 1846 and 1873. It's been called by some people, I think rather appropriately, a genocide, because some of those deaths were attributed to diseases to which California's native population had no natural immunity, but it was also the result of vigilantism by miners, state militiamen, and others who wanted the land that the Indians were occupying. as a result of this increased moving around, particularly in California, the federal government sent agents out to California, which was still a fairly new state in the early 1850s, to negotiate treaties with the tribes here. Because again, the federal government has, according to the Constitution, the power to regulate and manage Indian affairs. So these agents negotiated 18 treaties with various California tribes, including the Pechanga Band of Indians in the Treaty of Temecula Valley in 1852. But under the Constitution, those treaties have to be approved by the Senate, and that's a 2/3 vote. Well, that never happened in this case. And it never happened because of lobbying by California officials and politicians. So the Senate, when it was presented with these treaties, went into a closed session and voted not to ratify them at all. And that fact was not made public for another 50 years, which means that the Indians, the tribal leaders that had negotiated these treaties on behalf of their people, believed that they made a deal. They believed that they had reserved for themselves exclusive rights to certain pieces of traditional lands, but those treaties never went into effect. As a result, by the early 20th century, we have a lot of landless Indians in California. The Pechanga Band of Indians didn't get its reservation until 1882, so 30 years after it negotiated for land rights in 1852. And then finally, the Treaty Act of 1871. I had mentioned earlier that treaties are ways for sovereign governments to make agreements with each other. These agreements between the United States government and tribes ended in 1871 because the House of Representatives really resented the fact that the Senate had the authority to approve treaties, but it was the House of Representatives that was always asked to appropriate money to fund the treaties. If there was a promise of supplies, land, farming equipment, things like that, the House would have to appropriate the money, and they were tired of it. So there were no treaties made between the United States government and Indian tribes after 1871. There were a couple of agreements, but technically they weren't treaties. Now, this is an interactive map I wanted to share with you. It's been around for years and years, but it's charting the loss of tribal land since 1776. And you can see what starts out in blue is land that was under tribal control in the 18th century. And what we end up with are these little pockets of red, and those are lands that exist today as Indian reservations, lands that were set aside for particular tribes or groups of Native American people. And as you can see, the red is just a fraction of what the blue was back in 1776. And it looks like if you look at California, particularly Southern California, there are large chunks of red representing Indian reservations. Those are really tiny, tiny reservations that probably blur together on a map of this scale. Reservations in Southern California are especially small when you compare them to reservations in, say, Arizona, South Dakota, Montana, other states where there's a large Native American population. I also want to bring to your attention really an ugly mark on the reputation and history of California. So California has been a state for 175 years about, but shortly after it entered the Union, California passed a law for the government and protection of Indians. And again, this was a state law. Technically, most laws dealing with Native American affairs are federal laws because of the Indian Commerce Clause in the Constitution. But California felt that it needed and had the authority to pass its own law. And this law was incredibly discriminatory and I would say devastating to California's Native people. For one thing, it allowed white individuals to approach justices of the peace to remove Indians from lands that they wanted, not lands that they necessarily owned, but lands that they simply desired. It also allowed people to go before a justice of the peace to obtain Indian children for indentured servitude. Indentured servitude, those words were not used in this law, but if you found an Indian child, a person under 15 who didn't have any parents nearby or any adults seemingly responsible for them, you could take that child to a justice of the peace and have them apprenticed to you. And I think it's pretty clear from the historical record that these children were used as servants. They weren't really apprentices in the sense that they were learning a trade that would ultimately support them one day. You could approach a justice of the peace to have an Indian declared a vagrant simply on the word of a white person. Their labor could be sold at auction. And to add insult to injury, no white person could be convicted of an offense on the testimony of an Indian. So, I know that California might have a reputation for being a left-leaning state. And I think indeed it is in a lot of respects. And certainly today, I think political leaders are making an effort to address the ugly history the state has with its Native people. But this is a particularly ugly history, and the wounds from it have not yet closed. So this is a really big topic. There's no way I can give a complete overview of federal Indian law in the span of 50 minutes or less, but a couple of things I want to highlight for you. You might have heard about them in the news. They're getting renewed attention, as they should. But in the second half of the 19th century, boarding schools were used to separate Native American children from their families, from their tribal communities, so that they would be forced to learn to speak English, to learn a trade, and to really break ties with their tribal communities and their cultures, including their languages. This happened to children as young as 7 and children as old as 16, sometimes and maybe even often without the consent of their parents. These children would have been taken, and because they were boarding schools, they were far away. Sometimes they were as far away as Pennsylvania, the Carlisle Indian Industrial School. Sometimes they were as close by as Sherman Indian School in Riverside County. But here you see a before and after photo of the same group of students, what they looked like when they arrived and what they looked like after they had been at the school for a couple of years. This was really part of the federal government's then policy of assimilation. The federal government also got into the game of cutting up and dividing up lands that had been negotiated for tribes, issued to tribes as part of executive orders. And they did this through the General Allotment Act of 1887. There were other ways this happened, but the Allotment Act is the most famous. It was sometimes referred to as the Dawes Act after the senator who introduced it. But the act essentially carved up existing Indian reservations into equal-sized parcels so that they could be allotted to individual Indians or Indian families. The idea here was to get these families or individuals to become self-sufficient as farmers or animal husbandry men, in other words, raising livestock. The parcels were almost always either 80 acres in size for an individual or 160 acres for a family. But it was meant to promote settlement, and it was meant to promote, again, another form of assimilation. And it broke up the land base that existed for tribes. And as a result of this process, this policy, over the next 50 years, so into the early 1930s, Indians lost about 90 million acres of land. And how did that happen? Very briefly, it happened because once the federal government allotted land on an Indian reservation, whatever was left over, in other words, whatever was not already allotted, was considered surplus land and put up for sale. So you could have white families buying land on what was previously an Indian reservation. And then you would have white and Indian families living side by side. Also under this act, the Indians who received allotments were to get them in fee, simple, so free and clear, after about 25 years. Well, once these lands became fee land, then they were subject to sale, foreclosure, mortgages. Indian reservations were not. Indian reservations were and continue to be held in trust by the federal government of the United States for the benefit of those tribes and the tribal members. But once that land changed from trust status to fee status, anything could happen. And a lot of Native people lost their land, like I said, through foreclosure, mortgaging it, even probably downright theft. So that contributed to the interactive map that we saw a little while ago. It was one of the very many ways that Indian lands were lost. You can see on the right side of the screen an actual advertisement selling Indian land. So again, this is not my spin on the process. The federal government, I think, was very open about boarding schools and the allotment process. Even people who claim to be advocates and spokespeople for Native Americans encouraged them to embrace boarding schools and the allotment process because I think they thought that allotments, boarding schools, assimilation in general would help Native Americans survive as a people. Fast forward, we've already had a world war, we've already entered the Great Depression, but in the 1930s, when President Roosevelt developed the New Deal, there was also a component that sought to reorganize Indian tribes and promote self-determination instead of trying to stamp them out and assimilate them. Like many things that come out of Washington, D.C., this was part of a compromise. So it probably wasn't passed the way it was originally written. And it certainly doesn't reflect the values of the tribes that accepted or adopted the Indian Reorganization Act. But in a nutshell, what it did was it, for once and for all, ended the allotment process. So while there have been no lands allotted since 1934, we still have allotted lands out there on different Indian reservations, including the Pechanga Indian Reservation, because those allotments were done before 1934. They've just remained in Indian families ever since. The Indian Reorganization Act also offered tribes the opportunity to adopt constitutional governments. Now, tribes had their own forms of government long before European settlement of North America, but they were not written down, and they certainly were not in the form of constitutions. But this is what was familiar to the United States in the 1930s, and they thought that they could offer these constitutional governments to tribes, and many tribes did in fact accept them and adopted tribal constitutions. their constitutions didn't really look like the United States Constitution in the sense that there were not three branches of government. There was usually just one branch of government. And there was an incredible oversight power on the part of the Secretary of the Interior. The Interior Department is the department that houses the Bureau of Indian Affairs, the agency that manages Indian lands. So the Secretary of the Interior still got oversight authority as part of these IRA constitutions. The Indian Reorganization Act also offered business loans to tribal governments so that they could engage in economic development and hopefully become self-sufficient. And it also referenced a process by which tribes could apply to have the United States take additional lands into trust for their benefit. So in other words, some of the 90 million acres that were lost between 1887 and 1934, Indian tribes could buy back land, and now there was a process for them to apply to have the federal government take that land into trust for them. It meant that the land would be protected, that the land would not be subject to property taxes, and the land would also be under the jurisdiction of the tribes. So that's something that continues to happen to this very day. By the early 1950s, though, the pendulum had begun to swing the other way. And why is that? A couple of reasons. The 1930s saw the rest of the Great Depression. And in 1939, World War II broke out. So by the time that war ended in 1945, the United States government had somewhat changed its priorities. Tribal government self-determination was no longer a goal of the United States government. There were other things on President Truman's mind and in the minds of senators and congresspeople at the time. So once again, the federal government decided to change course and revisit assimilation as its overarching policy towards Indian affairs. And it did this in two ways. They were both passed in 1953. One of them was called Public Law 280. Public Law 280 was a law passed by Congress that affected 5 specific states at the time, including California. And what it did is it took the criminal jurisdiction that the federal government had over Indians on Indian land, and it gave that jurisdiction to 5 states, including California. Now, this is the important part. It did not ask the state of California if it wanted that jurisdiction, nor did the United States ask tribes in California if they wanted the state to have that jurisdiction. So this, again, like so many other things, was something that just happened to tribes without their input, without their consent. Public Law 280 is still on the books today. So for this reason, California state criminal laws apply on Indian lands within the state. This is not the case in most states across the country. We are unique. It is the case in other places like Wisconsin, Minnesota, Oregon, and of course here in California. It's also important to note, though, that research has been done on this and it's been acknowledged by the Supreme Court. The fact that California has criminal jurisdiction over Indian lands within the state does not mean that the tribes themselves lack or lost that jurisdiction. In fact, tribes have concurrent jurisdiction to exercise criminal authority on their land. Most of them do not, for a variety of reasons, but it's still within their power to do so. The next way that Congress sought to assimilate Indians and tribes after World War II was through House Concurrent Resolution 108, again, adopted the same year as Public Law 280. What did this do? This House resolution actually terminated a number of Indian tribes. And what does termination mean in this context? It means that the federal government was basically ending its legal and political obligation to Indian tribes by cutting them off from any further services through the Bureau of Indian Affairs or the Department of Interior. It ended any obligations that the federal government had to these tribes or these individuals. It was a way of encouraging or actually forcing individual Native Americans, tribal members to assimilate, because if their relationship to the United States government was now over, that meant that they were no longer going to have access to federal programs like the Indian Health Service, the Indian education schools, things like that. In other words, this law attempted to integrate tribes, affected tribes, into mainstream society. And it didn't apply to all Indian tribes, it applied to certain tribes in certain states. I believe Congress chose which tribes it applied to based on their accessibility to other services and their ability or perceived ability to be independent from the federal government's trust responsibility. And then finally, closer to home, Congress passed a Rancheria Act in 1958 that terminated tribes in California. And altogether, about 109 tribes across the country were terminated through what we call this era of termination. That meant that the federal government's duties, legal obligations to those tribes came to an end. Most of them ended up, at least for the time being, without any form of economic development, without any resources or government programs, which, by the way, the United States had previously promised them in treaties, executive orders, and various statutes. So this began a pretty dark time in the world of federal Indian law. But tribes were not down for the count. You know, tribal sovereignty continued, it persisted, it exists today, and I would even say at the moment, tribal sovereignty is on the upswing. It's healthier, it's getting more respect from the federal, state, and local governments. I just want to share with you this quote from a Supreme Court case that was decided in 1978, Santa Clara Pueblo versus Martinez. Each individual tribe has the power to regulate internal matters and domestic relations and to enforce that law in their own forums. So the Supreme Court, anyway, had come a long ways from the dark period of termination in the 1950s, and certainly from the boarding school period and allotment period in the 1880s. Here we have a pretty bold statement from the Supreme Court acknowledging tribal sovereignty, the ability of tribes to make their own laws and be governed by them. And this has never been overruled. It remains the law. This is something that tribes like the Pechanga Band of Indians put into practice on a daily basis. And you can see there a sign for the Pechanga Government Center, which is where I work, lit up at night, because it's really, I think, symbolic of tribal sovereignty, especially given everything that tribes like Pechanga have been through. where does tribal sovereignty come from? Now, keep in mind, this is different from federal Indian law. Federal Indian law, as I said, was the intersection of uh, Indian affairs, tribal government, and federal authority over Indian affairs. But tribal sovereignty is something different. Tribal sovereignty is something that is inherent in tribes because, as I said earlier, tribes were governing themselves long before European settlement of North America. They were doing that through councils, through individual leaders, through kinship groups. But it's something that it's inherent in them. It's not something that the United States government through Congress or the Supreme Court or the president gave to tribes. It's something that they had within themselves and had been acting on for probably millennia. Tribes exercise their power to address crimes in their communities, to protect their people and their resources, and to defend themselves against enemies. Those enemies could have been people from other tribes and eventually people from other lands. Examples, I mentioned clan systems and kinship groups. The Haudenosaunee is what the Iroquoian people called themselves. Those are people whose government, pre-European contact government, included an actual confederacy of tribes, different tribes that banded together to make decisions on a global level, decisions that affected all of them equally. And some people have even suggested that the Iroquois Confederacy has actually been one source of inspiration for the federal government of the United States because it was a multi-branch system wherein each tribe was autonomous, but they came together through representatives for a greater good, kind of like our Congress today. So what do Indian tribes have power over? What does tribal sovereignty look like in action? It doesn't mean all tribes have all of these laws, but they certainly have the sovereign right to develop and enact these laws and then to be governed by them. These are things that I see in many different tribes. Certainly, Pechanga has a number of laws on the books that have been passed by the general membership or general council of the tribe. In other words, the adult voting members of the tribe must adopt these laws for them to take effect. But tribes have laws on, among other things, peace and security, family law, civil disputes, housing and land use, child welfare matters, domestic violence. I put an asterisk next to that because we're going to come back to domestic violence in another slide. Cultural resource protection, which is a very timely issue. Cultural resources can refer to water, timber, minerals, human remains, artifacts, all of the above. Internal governance, how elections are conducted, how exclusions or restrictions from tribal land are made, tribal enrollment determinations. So this is something that all modern day tribes have to consider. What is the eligibility criteria to become a member of your tribe? Is there a formal process? What kind of documentation is required? Who makes these decisions? These are all things that tribes have to think about in order to sustain and perpetuate themselves in the future. And many others. This, again, is just a partial list, not an exhaustive list. Civil jurisdiction. So tribes on their land enjoy civil jurisdiction over members, visitors, and guests, me included as an employee. But the boundaries of this civil jurisdiction are really tested by the Supreme Court case of Montana versus the United States. So again, we have the federal government kind of outlining the jurisdictional boundaries over when and how a tribe can regulate the conduct of non-members on tribal land. And the Supreme Court came out with a two-part test. And satisfying one of these two prongs will determine whether or not the tribe does in fact have civil jurisdiction over the individual or his conduct. Prong one is whether or not the non-member enters into a consensual relationship with the tribe or its members. So the easiest example would be a contract. But two, if the non-member's conduct on fee land, which was the situation in this case, whether the non-member's conduct on that land within the reservation threatens or has some direct effect over the political integrity, the economic security, or the health and welfare of the tribe. So if you're doing something on Indian land or within the boundaries of an Indian reservation that would affect one of these things, the political integrity of the tribe, its economic security, or its health and welfare, then you too would be within the tribe's civil jurisdictional orbit. So it's something that's important to know, because when we think back about the allotment process a few slides ago, that tells us now that it's actually quite common for non-Indians to own fee land within the borders of an Indian reservation, because that's an allotment land that at some point went out of trust. So it's quite common now to have non-Indians own fee land within the borders of an Indian reservation. But that doesn't mean that those non-Indians can get away with whatever they want. They are still within the jurisdiction of the tribe, provided one of these two prongs is met. So that's the Montana case. Very important in tribal communities. What about criminal jurisdiction? And I'm just going to tell you, this is messy. I don't expect anybody to come away with a clear understanding of criminal jurisdiction in Indian country, because I don't know that it exists. The best we can do is try to interpret the law and recognize that it's not only possible, but very likely that multiple governments share concurrent jurisdiction at any given time. So we have Congress passing a law in 1817 called the General Crimes Act, which brought non-Indians who committed crimes against Indians in Indian country under federal jurisdiction. But then about 68 years later, the Major Crimes Act said that Indians who commit major crimes against anyone in Indian country are also under federal jurisdiction. By the way, I just want to note here that Indian country is not a phrase that I made up. It's actually a phrase that's been codified by statute, and it's defined as Indian reservations, allotment lands, or, and dependent Indian communities. But for our purposes here, we're really talking about Indian reservations. So fast forward from 1885 to 1953, we talked about Public Law 280 a little while ago. It was part of the federal government's effort to assimilate Native Americans and tribes, once again in the 1950s. So Public Law 280 changed the landscape of criminal jurisdiction in that it took this federal jurisdiction over crimes committed in Indian country, and it gave it from the federal government to 5 specific states, including California. Public Law 280 has been amended a couple of times over the years, but it has never been repealed. It's still on the books. Public Law 280 is still in effect in California today. What's changed is that outside of the law, other states can seek public law 280 jurisdiction from the federal government. The only difference is since 1968, the tribes in those states must agree to it. Back in 1953, when this law was originally passed, nobody asked the Indians if they wanted this, and none of them consented to it. It just happened to them. So again, federal Indian law, the lives and governments of today's Indian tribes are inextricably linked to the federal government in a variety of ways. Oh, and before we talk about those cases, I just want to mention something about Public Law 280. It may come up in a later slide, but California doesn't have the power to tax Indian tribes or individual Native Americans living on Indian reservations in California. So California probably wasn't too thrilled with Public Law 280 either, because it gave them much more responsibility, more land to patrol, more laws to enforce, but zero extra tax dollars to do all of the above. The landscape of criminal jurisdiction on Indian land gets even murkier. In 1978, the Supreme Court told us that Indian tribes lack criminal jurisdiction over non-Indians, even within their own reservation lands. Why is this? The Supreme Court said that that kind of jurisdiction is inconsistent with the tribe's status as domestic dependent nations. So that was a term that was introduced in 1831, yet here it was being referenced by the Supreme Court in 1978. The court also felt that that jurisdiction was inconsistent with the rights of individual Americans who were not tribal members. In 2013, the Violence Against Women's Act was updated and reauthorized. This act originally goes back to 1994, but the act was reauthorized with some new language that included, for the first time ever, enhanced criminal jurisdiction for tribes over non-Indians. This was a big deal. In order to get this enhanced jurisdiction, though, tribes had to opt in, and this was specifically to deal with domestic violence, which unfortunately is a big problem in many Indian communities. And in order for tribes to get this special enhanced jurisdiction, they were required to provide certain due process rights to the non-Indian defendants charged with domestic violence. The tribes had to provide or have to provide a law-trained judge. Their laws must be available to the public. There's got to be court-appointed counsel for indigent defendants. The proceedings must be recorded, and the juries, if there are juries, must represent a cross-section of the community. And what I can tell you from my work in tribal courts is most tribes provide these things anyway, but most tribes I work with are not exercising their criminal jurisdiction at this time, especially in California, because we're a public law 280 state. So if a crime occurs on a reservation in San Diego County, the San Diego County District Attorney could prosecute that crime. The tribes don't need to do it themselves, but they could if they wanted to, under certain circumstances like this. This is just a chart. I really threw this in because I thought how funny criminal jurisdiction on Indian land is so confusing. And notice, it's the only area of law that I know of where you have to ask the question, are you Native American? Are you Indian? If so, what tribe? This is how we determine who has jurisdiction over whom. There would be a civil rights case if if a highway patrol officer pulled over a person and asked them other kinds of racial questions. But here, it's necessary to figure out whose criminal jurisdiction applies to that particular situation. I just wanted to share a couple of things about tribal communities today because I don't want to leave anybody with the impression that the federal government gets to control tribal governments. That's why I was talking about tribal sovereignty, which is very vibrant today and really just shows that the sky is the limit when it comes to Indian tribes in terms of economic development and making their own laws to govern their own people. These are just some photos of the Pechanga community where I work and which I'm very proud to be a part of. The casino, but also the great oak, which is a sign of resilience. That oak tree is one of the oldest oak trees in the United States. It's over 1,000 years old. And then some examples of Pechanga basketry in the corner. And then those are members of our tribal council with donation checks to local charities. There's 574 tribes recognized by the United States government today across the country. California has the largest Native American population with 723,000 people. I can tell you that as of the 2020 census, that number is now over 1 million. And I want to point out that Native American ancestry does not equal formal enrollment in any tribe. You can take a 23andMe test or an Ancestry.com test and find out you're 37% Native American, but that by itself does not make you a tribal member. You still have to apply and be approved under each particular tribe's membership criteria. There's 278 reservations throughout the country, reservations that were set aside for particular tribes. And these reservations range in size from 16 million acres for the Navajo people. It's most of eastern Arizona. It spills into New Mexico. To tiny reservations like the Hamul Reservation in southeastern San Diego County, which is barely 6 acres. You can see that California is very diverse just in terms of its tribal makeup. We have 109 tribes recognized by the federal government in California. 18 of those are in San Diego County, more tribes than any other county in the United States, which is a pretty cool distinction and a really fun kind of cocktail party trivia question. I think a lot of people would guess it's somewhere on the Great Plains or in Arizona or New Mexico, but nope, it's San Diego County. And we have tribes in California that are not recognized by the federal government, but they are recognized by the state. We do have many tribes with tribal courts. Sometimes these are standalone courts. Sometimes they're consortium courts, which just means that multiple tribes pool their resources to form one court to serve all of their needs. And in San Diego County, we have 3 tribal courts. The Intertribal Court of Southern California, which is based in Valley Center and has 14 member tribes. We have the Pala Tribal Court, where I had the privilege of being the judge for 4 years. And then we have the Rincon Tribal Court, which is also on the Rincon Reservation in Valley Center. Pechanga has its own court. We're technically over the Riverside County line. So I wanted to be respectful of time, but I wanted to make sure that everybody, if they have questions, had an opportunity to ask them. I apologize if I went too fast through any of those slides, but I just know this is a topic that a lot of us spend semesters in law school learning. I just wanted to give a brief overview, and I hope I didn't confuse or overwhelm or bore you. Rather, my goal was to just give you a sense of how complex but also interesting the field of federal Indian law can be. It's a very broad overview. It's what I could do in 15 minutes, but It's what I've done the majority of my professional life, and it's constantly changing. But it continues to fascinate me. I do see in the chat there are some questions. Rianne, I don't know if you want to read them or you want me to go through them.
Yes, thank you so much, Mark. It's such a wonderful presentation. So the first question is, can you reveal or share your insights on how the Fourth Amendment works on tribal lands, meaning the protection against unreasonable search and seizures? Does it have a narrow application or a wider one? Or maybe does the Fourth Amendment depend on the tribal compact for specific tribes and state legislatures?
I'd say it probably and it should have uh, the same application as it does off of tribal lands. It's really just a matter of which government is conducting the searches and seizures. But tribal members are also American citizens. That was a separate act passed in 1924, 100 years ago. So tribal members are not only members of tribal governments, but they're also US citizens. So they carry around with them the same rights as other US citizens under the Bill of Rights. But tribes also cannot violate the rights of tribal members under a law called the Indian Civil Rights Act. But searches and seizures conducted on tribal lands should be done the same way with the same level of protocols and um, uh, reasonable standards that they are conducted with off the reservations. Sometimes they're conducted by federal officers, depending on what state you're in. Here in California, they would be conducted by state officers and possibly tribal officers, but the same protections against unlawful searches and seizures should apply.
Thank you so much, Mark. And then for the attendees that are still here, we do understand that it is 1:02. So you are free to stay in the presentation with us. And if you do want to hop off, that is perfectly fine as well. But we do want to answer some questions that we still have here. So the next question is, in the context of California Penal Code 11411, enacted on January 1st, 2023, a ban on the swastika, has this affected the local tribes who use the similarities of the swastika?
Oh, so that's not an issue I've heard about. Not the swastika ban, but the application to tribal symbols. And I'm not sure what those would be unless they're tribal seals or logos, of which I think every tribe has one. So I'm not familiar with it. Regulatory laws of California do not apply to tribes on tribal land. If it was a symbol that was simply similar to a swastika, I don't believe that that provision of the penal code would apply to tribes. I think it would have to clearly be a swastika in order to implicate any kind of state criminal laws. But I'm personally not aware of any issues arising out of that provision.
Thank you so much, Mark. So another one we have here is, I'm in an Indian politics class right now. So this was very complimentary to her course, to their course. In your opinion, what would it look like if tribes truly receive full sovereignty?
It's a great question. So what I can say is, federal Indian law is now over 200 years old. My little part of it has been 20 years, and what I've read about the past before I started practicing. I feel personally that tribes are as sovereign today as maybe they have ever been in the certainly last 100 years, maybe last 150 years. what would full sovereignty look like? Well, I think you would have to answer that question by considering, like, if tribes were to take the federal government completely out of the equation and have no attachment to them whatsoever, um, keep in mind tribal land might fall out of trust. Grant opportunities and support through the Indian Health Services, the Indian Board of Education, the Bureau of Indian Affairs, those services might come to an end. And my sense is that while all tribes want to be as sovereign as possible, I don't know that any tribe wants to give up any of those services because their members benefit from those services. But I think economic development helps tribes become more sovereign and exercise their powers. I hate to tie that to money because it's not just about money, but I do think tribes need money to implement their vision for their future and to be more self-governing. Um, so just my thoughts. Um,
Thank
any
you.
rec? Oh,
Sorry.
sorry. Any recommendations for books that would provide legal background on the issues discussed today? One of my favorite books, I'll give you two recommendations. The Rights of Indians and Tribes by Stephen Pivar. He's a former ACLU attorney and a current Indian law professor. That's a great book. I used to teach out of that at a local college. The other book I would recommend, it's not so much on the black letter law, but it's about the history of California tribes and it, I think, successfully makes the argument they were victims of genocide. It's a book by Professor Benjamin Mandley at UCLA. He's a history professor, and I think the title is American Genocide. It's a fascinating but heart-wrenching read. It really gave me a new appreciation for what California tribes went through and why they were in the state they were in the early 20th century. And finally, what is your take on how tribes should approach gambling facilities on reservations? Well, Pechanga has a big gaming facility, and I have to say that um, I would advise anybody who questions Indian gaming to think about what that money does, what the money tribal casinos does, because tens of millions of dollars from Indian casinos go back to the state of California. Every tribe with a casino in the state, as long as it's operating a certain amount of slot machines, is sending money back to the state of California, and that money is going to um, uh, gambling, Gamblers Anonymous, educational programs, but it's also helping tribes realize their dreams, take care of their own people, provide their people with great health care, with economic opportunities, develop police and fire departments, tribal schools. So I've heard people say, well, gambling's not a good way to make money, but you also have to keep in mind that a lot of tribes are occupying lands that are really in remote locations. They need something on those lands that will bring people to those lands. And a Starbucks is not going to do it, right? Because people can go to any corner of any city and get Starbucks probably, but they don't need to go um, into the remote lands of San Diego or Riverside counties. But they might want to go to see Air Supply or the Eagles or Jerry Seinfeld perform, or to try their luck at a slot machine. So I think gambling has become important to tribes as a form of economic development. And again, there is that link to tribal sovereignty.
Wonderful. Thank you so much, Mark. I don't see any further questions. And we just want to thank you again from the San Diego Law Library and the community. This is such an informative presentation. Thank you for all the participants today. And just have a wonderful rest of your day.
Thanks so much for the invitation. It was a pleasure.
Oh, you're welcome. Thank you. Have a good day.
Bye-bye. You too.
Bye.